Exposing the truth to Judge Collins of North Carolina. This is Haley Brooks. She was killed because another locality had an unsafe parade. This is what happens when you see parades.
Oh my God!
Oh, it's safe.
Oh my God!
Oh, they fell.
Oh my God!
Oh, it's safe.
Oh my God!
Oh, they fell.
Oh my God!
Oh, it's safe.
Oh my God!
Oh, they fell.
Oh my God!
Oh, it's safe.
This is another person being killed, July 4th, by another unsafe parade. Here's another person being killed by another unsafe parade. We have more. Here's another person being killed by an unsafe parade put on by a locality with no safety standards. Here's a school system killing their own kid in South Carolina. Now, why do we have to keep up the effort? Here's what the Supreme Court of Texas said. As you read this, before the incident with Haley Brooks, the Supreme Court of Texas agreed with our information that the locality, in this case, Midland, Texas, was responsible for the death of the 4 wounded warriors. It's very clear. The NTSB heard our argument in 2011. Now, as we go further, the lawyer did a very poor job explaining his position. The city of Raleigh's attorney is trying to argue immunity. If we keep doing this, no one's held responsible. Here's the deposition.
One step closer into finding out who in the city can be held responsible, even if they can be held responsible for the death of Haley Brooks in the 2022 Raleigh Christmas Parade. The final day in the civil lawsuit hearing brought forth by the family of Haley Brooks against the city of Raleigh heard arguments from both sides, as the Brooks family looks to hold the city responsible for the death of their daughter Haley in the 2022 Raleigh Christmas Parade.
This case is about negligent event planning, negligent safety review, negligent crowd management, negligent operational coordination, and the foreseeable interaction of vehicles and children in the same parade footprint.
The burden is on the plaintiff to convince you by a preponderance of the evidence what happened.
At odds is the city's position that it has governmental immunity and therefore cannot be held liable, whereas the family disagrees, calling the city co-operators and co-planner of the parade.
To say that the city was not responsible does not jive with the written record. It doesn't jive with the understanding of the parties in this case before Haley Brooks was killed.
What we believe the plaintiff is trying to do is get the court to strain the bounds of long-standing law and defy the well-established precedent and really take us into territories that the law has never been.
I'm going to read every word of every bit of it.
UNC law expert Kate Sobolowski-Ellengold says there is a lot that the judge will be looking at.
It sounds like there are arguments being made on both sides about these offshoots of the idea of immunity. So was it proprietary? Was it governmental? Was the person acting within the scope of their employment? Were they not? Those things are all fact-based inquiries that a judge will have to determine.
And right now, Judge Collins is reviewing those arguments, going over the briefs in his chambers, and in his words, he's going to pore over everything. No word yet on how soon we can expect a ruling. Lauren?
So you just heard a lawyer who did a very poor job explaining to the judge that there was prior reporting and prior judge precedents on this problem. So once again, Judge Collins of North Carolina has a decision to make. As Memorial Day weekend comes up, we're trying to prevent the next death or injury by these unsafe parades. And whatever happens, it's on this judge's decision.